So in Fulton, you had Catholic charities, which had to be incorporated. It was incorporated, separately incorporated under state law, and could only provide adoption services with incredible oversight from the city. I mean, they can't take foster children in. They can't place them without comprehensive governmental involvement. What's the difference? How do we draw that line so that we capture public schools on your account, but we don't capture, and you seem to say we shouldn't capture, entities like Fulton? And by the way, I'm delighted to hear they're still teaching the problems of dangling modifiers in Oklahoma schools. Right.
That was Supreme Court Justice Neil Gorsuch. Oral argument during the case Oklahoma Statewide Charter School Board versus Drummond. The Supreme Court, in a 4-4 decision, ruled against Oklahoma establishing the nation's first religious public charter school. At the end of that clip, you also heard in the courtroom a little laughter. Why did Justice Gorsuch's line about dangling modifiers get a laugh? And could he have made it even better? In this episode of C-SPAN's podcast, The Weekly, we find out. Because it's our annual end-of-term Supreme Court Comedy Festival. Hear the top 8 laugh lines from this Supreme Court term, then find out why they were funny, then find out how they could have been made even funnier still, then hear the jokes ranked. How are we going to pull off this daunting comedy feat? Simple. We'll be joined by a very special guest, an actual comedy professional, to walk us through all of this year's SCOTUS humor, with legendary and hilarious comedy writer Jon Macks. Jon Macks has been writer and producer of over 300 live television shows, including a record 27 Academy Awards, serving as head writer 14 times, writer for 22 years on The Tonight Show with Jay Leno, writer for Jay Leno, Billy Crystal, Chris Rock, Helen Mirren, Marty Short, Steve Martin, Michael Douglas, Queen Latifah, Terry Bradshaw, Hugh Jackman, Anthony Anderson, and over 24 U.S. senators and CEOs. Executive producer of the 2024 documentary Carville, Winning is Everything, Stupid. 10-time Emmy nominee and 2-time winner of Writers Guild Award. Jon Macks has worked on presidential debate prep in every election from 1996 through 2020. And he's the author of Monologue, What Makes America Laugh Before Bed. He was also writer of Kamala Harris's 2024 DNC video, narrated by Morgan Freeman. And he was one of the head writers for the 2020 Democratic Convention. Also, he was writer for the Biden-Harris inauguration, Celebrating America, and the Parade Across America. But most important for this podcast, Jon Macks has a law degree from Villanova University, Charles Widger School of Law. So for this podcast, consider Jon Macks to be our comedy counsel, and he's contributing his skills pro bono. Jon will rate and rank each joke. He'll tell us why it got a laugh. Would the joke get a laugh if, instead of during the oral argument, the justice performed it on stage at Zany's Comedy Club? Could he offer a touch-up or a follow-up or a tag? And if he were on the Supreme Court, what joke would Justice Jon Macks have made? Jon won't be judging the justice. He'll be judging the joke. Okay, let's get started. Justice Gorsuch said, I'm delighted to hear they're still teaching the problems of dangling modifiers in Oklahoma schools. Jon Macks, why was that funny?
First of all, it's great to be here with you, Howard. Let's start with this. There's 3 basic rules when you go into these things. One, you want economy of words. Second, you want a different way to look at things, a novel way. We call it don't go for the low-hanging fruit. But third, you want to end on the punchline. The problem with this joke is he didn't end on the punchline. Dangling modifier is the funnier word, not Oklahoma schools. So if I had been advising him, he would have said, so Oklahoma schools are still teaching about dangling modifiers. That is a better way of going about this. I would say, like on a 1 to 10, you give it a 6. It was good. It was in the moment. But I would have tweaked it a little bit. It probably could have taken it up to a 7 or an 8 if he did that.
Does he get credit for being spontaneous at all?
Always spontaneous. It's if he were doing panel on a late night show. You want something like that. It's somebody who's an ad lib, an improv, a reactive person. Somebody says something, use something else. Anything that seems too set up is not going to be as good as something that is clever. Clever and quick is better sometimes than funny and written.
Would Justice Jon Macks have done that set up a joke or improved it in any way, or not even gone there?
Let's see. I'm delighted to hear they're still teaching the problems in Oklahoma schools of dangling modifiers. I would have probably tagged it. And
what does that mean,
said, and a dangling modifier, that better not be an Oklahoma sex ed. So I would have tagged it. I think that would have taken up to the next level.
All right. Next Supreme Court oral argument in Free Speech Coalition versus Paxton, a case about a Texas law requiring age verification for users visiting pornographic websites. You'll hear Justice Samuel Alito and attorney for the petitioners, Derek Schaefer.
Justice Sotomayor mentioned some of the precedents that have been cited by the parties in this case. She didn't mention Ginsburg versus New York, which was perhaps the decision that the Court of Appeals relied on most heavily. So I would like you to explain why rational basis was appropriate in Ginsburg and not appropriate here. What you say in your brief is, the law at issue in Ginsburg did not place any restriction on adults' access to sexual materials. It did not, for example, require sellers to conduct age verification of adult customers. How can that be true? Suppose a youngish-looking person went into Mr. Ginsburg's store and wanted to buy a girly magazine. Mr. Ginsburg faced the possibility of criminal prosecution if he did not verify that that person was not a minor. So why is there not age verification built into the issue in Ginsburg?
Justice Alito, if it's built in, it's tailored age verification, just as you were suggesting with the question. Most purchasers, if I myself were the purchaser, I don't think I would be carded. The New York law said that if there was a knowing sale to a minor, or someone whom the seller should suspect to be a minor, that was the exceptional instance where you might have, subject to the seller's discretion, some reasonable effort to ascertain the age.
Well, if what you're facing is possible criminal liability, you may want to err on the side of safety. I know that when I try to buy wine at a supermarket, they require me to show an ID. I take it, I'm flattered by it.
Okay, Jon Macks, Samuel Alito, flattered by being required to show an ID, and he got laugh in the oral argument. Tell us about that.
First of all, he's going for self-deprecating a little bit. And the first thing I would do is, it needs a little economy of words. He dragged it out. I would have gone something like, I know when I buy wine at the supermarket, they make me show an ID. A little tighter, gets to this punchline a little bit better. I also then would have probably recommended he tag it with, I showed them my AARP card, and they wouldn't take my Supreme Court ID. It's okay. He's self-deprecating there a little bit, talking about his age. He's getting, in one sense, what we call a courtesy laugh. There are people in the Supreme Court that want to show that they think he's funny. I'll always give an example. When Chris Rock walks on stage in a club when he's trying new material, unfortunately, sometimes he's just going to get a laugh because it's Chris Rock, and you don't get to really judge the material. So when Chris, for example, is preparing for a special, when he goes to a club, he'll literally, with no intonation, just read the basic joke, just so they're not reacting to Chris Rock doing it. They're reacting to the words in the joke. Now, if I were doing this joke, I give this joke probably a 5 on a scale of 1 to 10. It's okay. It's good. He's trying his best. I probably, if it were me, I would go, I know when I buy wine at a supermarket, which I do every day before I come to this court, I make me show an ID. I would have put something in the middle right there to really break it up. Throw a change up in the middle. Again, not bad, but not high level.
I'm intrigued that the joke and the punchline and what you're talking about has nothing to do with the earlier talking about sexual materials, pornography, which you normally don't hear in a Supreme Court setting.
Right. Again, he could have done that. Again, for me, I would have said, by the way, you can't get Pornhub in some parts of Virginia. Just a friend told me that. He could have done something like that. But given who he is, one, it would have been hilarious, but also so out of character.
Yeah.
Again, that's why so far my nomination has not been submitted to the Supreme Court.
All right. Our next, and again for the listeners, these are jokes, laughed lines that from the oral arguments, and we're playing 8 of them with our guest Jon Macks. Next, the case of Garland versus Vanderstock. The Supreme Court voted 7-2 to uphold a Biden administration ghost gun regulation, ruling that it was consistent with the Gun Control Act of 1968. You'll hear again Justice Alito and former Solicitor General of the United States, Elizabeth Prelogar.
On what it means to be readily convertible, I don't know whether it's possible to do something, that's the statutory term, I don't know whether it's possible to do something more precise than what ATF has done, but it would be interesting, if it would be helpful if you could perhaps explain a little bit more what that means. So what level of expertise is taken into account? What collection of tools is taken into account? Can you provide any sort of a time limit? How long must it take? Some of us who don't have a lot of mechanical ability have spent hours and hours and hours trying to assemble things that we've purchased.
I'm with you on that one, Justice Alito, as someone who struggles with IKEA furniture.
All right, Jon Macks, I have to tell you, I'm going to jump in. Word IKEA is funny. Maybe that's why I got to laugh, hard case down, but I'll leave it up to you. They're professional.
Yeah, IKEA is a funny word. Yeah. But to me, this is really, I wouldn't even call this really a joke. This is more an observation. It's a statement. It's, again, he got a courtesy chuckle. A comparison joke would have been better. Like, he's trying to make the point, I have a law degree. I got a 4.0. I'm one of 20 people who still can drive a stick shift. But asking me to assemble something is like asking the Colorado Rockies to win a baseball game, like asking Jennifer Lopez to stay married, like asking Joe Biden to stay awake past 7 p.m. Any of those things would work better. Now, if he really wanted to go edgy, if this was, and this sounds like it's his second show that day, but if it was the later show, he said, look, I don't know how to assemble stuff. Look at me. I accidentally flew my wife's flag upside down. So, I mean, he could do something like that to really take it. Honestly, I give this a 2.
Oh, my goodness.
Yeah.
All right. We've had a 4 and a 5 and now a 2. Wow. Okay. Can I divine that you are not a fan of observational humor?
I am if it takes it to a different level. If it's just, again, it's that old thing about, hey, how about mailboxes? It needs to be a joke, not just a statement or an observation. Look, a great comic says things on stage that everyone in the audience is saying, that's right. I could have said that, but they can't because they're not on stage. They see things different. Or the really greats take it and give it a twist that you could never have imagined, and takes it and makes you, again, think. Again, the perfect example of that is a Chris Rock. Is just takes you down one path and just completely flips it. And again, with Chris, and again, obviously I'm close to him and he's a favorite. He's great. It's not observational. I mean, he's taking something that exists that we know, a similar situation, a familiar situation, but taking it to a different level.
All right, let's see if the next one scores higher than a 2. Again, we're talking with legendary Hollywood comedy writer Jon Macks, hearing the funniest jokes told during oral argument this Supreme Court, this just completed term. Next, the case of TikTok versus Garland. The Supreme Court upheld a law requiring the TikTok app to divest from Chinese parent company ByteDance or face a nationwide ban. Here again is former Solicitor General Elizabeth Prelogar and Justice Gorsuch, joined by Justice Amy Coney Barrett and Chief Justice John Roberts.
And you're saying we have no alternative but to stop this speech altogether. We can't rely on disclosure. But you say that wouldn't apply to Politico or to the Oxford University Press because?
In the circumstance where you have a newspaper that is understood to reflect its publisher's views, then you might think that disclosure would be a more adequate remedy there because it's not just holding itself out as a forum for speech between other people. I think social media platforms do raise distinct interests in this regard because what people think when they're engaging with TikTok is that it's organically feeding them videos based on the recommendation engine. And if actually China is behind the scenes engaging in this kind of covert operation, it does prevent a distinct national security risk. Of course, course, the other big difference with the newspaper is it's not likely to be collecting sensitive personal information about 170 million plus people and then having the capacity to send that back to a foreign adversary.
General Prelogar,
Counsel,
can I? Oh, go ahead.
I was just going to say, did I understand you to say a few minutes ago that one problem that ByteDance might be through TikTok trying to get Americans to argue with each other?
That it might be just trying to foment
they do, I say they're winning.
or dissent.
Okay, Chief Justice John Roberts got a laugh because he's Chief Justice or because that was funny?
It was a great joke.
Okay.
It was a great joke. He did his own setup. It was an economy of words, as opposed to Justice Alito, which is a statement. This had a point of view. I mean, I thought on a 1 to 10, I give it an 8.5. It was in the moment. It was spontaneous. It was very quick. I thought it was great. He could have, throughout the whole thing, obviously put himself in the position of making fun of himself as someone who has seen TikTok, who make fun of the words ByteDance or whatever, but I thought this was great.
So this is the second time, Jon Macks, that we, two potentially funny words or phrasing, the low-hanging fruit, they didn't go for, and you are rewarding them with higher scores.
I'm giving them a higher score for that, and it was right in the moment. And again, if they do, I say they're winning perfectly. Look, he could have said, I think they're winning. It's the same. We're talking about a second there. He's getting right to the punchline. It is something we could all agree with because it's something we go, yeah, they are winning in this and disrupting things. I thought I was very impressed.
Well, fabulous. Is there any element of this, though, because he's Chief Justice, maybe he just is a better joke teller by being a Chief Justice? Is that...
He might be in the sense of I know there's a couple roast comics on the court right now in Justice Jackson and Justice Barrett. I think they're both involved in a roast off with Jeff Ross moderating. But I think the fact that he is able to deal with those many personalities, I think as Chief Justice, he's imbued with a certain thing. Again, when you come out to host a show, you're the captain of the ship. He is the captain of the ship. Even though there's other people speaking in this is his moment to interject. And I thought it was great.
All right, Jon Macks. Next is the 7-County Infrastructure Coalition versus Eagle County, Colorado oral argument. The Supreme Court voted 8-0 that federal agencies do not have to consider the potential and indirect environmental effects when approving projects, and that studying the immediate effects is sufficient. For the petitioners, you'll hear Paul Clement and Justice Elena Kagan.
The FERC pipelines are probably the hardest case because, and I think they're less remote in the sense that, the pipeline might go all the way to near a power facility. And the D.C. Circuit has this Sable Trail case, which we don't like very much. And we would say even in Sable Trail, pipeline goes to the plant, but the emissions of the plant are regulated by Florida, and so that's a case where you don't have to study the greenhouse gas emissions. That's our position. But you could disagree with us on that because you think our test would apply a little differently to the pipeline. But I think our test is a pretty good start. And look, in the realm of defining proximate cause, if I could give you a 10-word test that took care of every hard case, they'd give me tenure at Harvard. But I think, having
I'm sure they'd give you that anyway.
Okay, Jon Macks, and you're a lawyer, so let's talk about the laugh line here.
First of all, Elena Kagan sounds like a comic's name, so it's great. It's got that hard K sound, which is wonderful. I was not wild about this joke. It's a little, because it's inside baseball. It's presupposing knowledge about Clement and being at Harvard and something about it. So if you know that, it's fine. Otherwise, it's a little too Dennis Miller. It's in the sense of it's presupposing you know something about this person. To me, I would have taken it broader. When they give me tenure at Harvard, she'd go, wait, they still give tests at Harvard? Something like that. Or why would anyone want tenure at Harvard? Something like that. I said, well, yeah, tenure there, but not at Yale. Something that takes it to a slightly different level than operating within. I like her timing a little bit. The truth is, Clement's line was actually just as funny. They give me tenure at Harvard is the same.
Yeah, and you normally don't hear the plaintiffs getting, or the attorneys arguing the case in front of the Supreme Court getting laughs from the audience either. That's tough to pull off,
Right.
I'd imagine.
Also, her timing was off a little bit. I would have given a pause. He was still kind of in the middle of his sentence when she interjected, which a justice can do, of course. They're allowed to interject anytime they want.
With all due respect.
Yeah, with all respect to them. But, again, I give it probably a 4.5, maybe a 5.
So if I hear you correctly, this would not work at Zanies, but it would work at the American Bar Association.
Exactly.
Okay.
Perfect. Inside knowledge, or at the Harvard class of 1984, where Clement was, or wherever he was. Perfect. Hilarious there, because they know. But otherwise, people are going, wait, what?
All right, Jon Macks is being tough today. All right, next, the Supreme Court heard oral argument in Cuisis versus United States, a case on whether deception to induce a commercial exchange constitutes mail or wire fraud, even if inflicting economic harm on the alleged victim was not the object of the scheme. Here's an exchange between Justice Alito and attorney for the petitioners, Jeffrey Fisher.
Well, I don't know whether that's a very odd result. Suppose I have 2 trees in my yard. One is an oak, and one's a weeping willow. And I hate the oak because I'm tired of raking up the acorns. So I hire somebody to cut down the oak tree. And when I come home from work that night, the oak tree is still standing, but the weeping willow is gone. And he says, well, the oak is a healthy tree. It's got deep roots. The willow has shallow roots, and any storm could knock it over, and it could damage the house. Have I not been defrauded there? I didn't get what I wanted.
I think you might have been harmed there with the property of your tree being taken away. I mean, I think I think that's just an odd hypothetical, but with a normal service,
well,
I
could give you 1 million of them. I hire somebody to paint the dining room of my house. And when I come back, the dining room has not been painted, but the living room has been painted. And the living room is bigger. And he says, look, I gave you a bargain, same price, I painted more, plus the living room really needed it more than the dining room.
I think we're still in this difficult situation of there's actually, your home is your property, and so some of the things that are happening to your property.
All right, Jon Macks, so the setup for this one began with raking up the acorns, and it kind of went in a different direction. So tell us what your thoughts on this joke.
This, to me, again, and this is with all due respect to the justice, just goes nowhere. As great Kanye West would say, it's bupkis. There's just nothing there. First of all, I would have the idea of him raking up his own acorns. I would have just gone with that. The idea of him then saying, now, as I often do, I was out raking my acorns in my judicial robe, as one would expect. And if he could take it and paint the picture that way, so you see that visual image that is just so out of sorts, putting a justice, again, fish out of water, him raking acorns. Then he goes on with a hypothetical, which is basically the same one. I would have suggested that he do something, take it outside in a bigger way, and I would work off when he said, I didn't get what I wanted. Then again, I'm married. Or I didn't get what I wanted. As Kamala Harris said, join the club. Or I didn't get what I wanted. As Glenn Close says at Oscar time, tell me about it. He could have done it and taken it in a much broader way than limiting it that. I, again, did not think that this was... I would say that he needs to do a lot of open mic work at this point, and really at the 1 a.m.
The 1 a.m. show.
Yeah.
When everybody's drunk. You mentioned judicial robes, and it struck me when you're saying that the setup in these oral arguments, and we're playing audio from inside the oral arguments, there's a big red curtain behind them, and the judicial robes are all black. And I'm wondering, does that add at all to the comedy aesthetic of the oral arguments? Or?
I think anything that's visual can add to it, right? And again, but they're not painting a picture. They're lawyers, they're justices, they're just using words, but they're not using them to paint a picture. They're using them just to make a point. Paint the picture and make the point, you're a lot better.
Okay, so a brick wall behind them really wouldn't help this joke.
Exactly.
Okay, gotcha. All right. Next with Jon Macks, we have 2 more jokes, laugh lines to play with Jon Macks. The Supreme Court heard oral argument in Delegati versus United States, a case involving an associate of the Genovese crime family convicted in a murder-for-hire plot. Here's Justice Gorsuch and attorney for the petitioners, Alon Kedem.
Mr. Kedem, Our intuition is that often omissions are just as bad as acts, and they're sometimes hard to distinguish. And certainly it can be murder when there's a pre-existing duty of care that you then omit to fulfill. All right. But there are some places where they have gone well beyond that common law rule and imposed a duty of care even for the Good Samaritan. So let's take a hypothetical. Someone comes across the streets, sees that the manhole cover's open, doesn't rescue the little old lady who steps into it because this person has animus toward little old ladies. Now, extreme hypothetical. Justice Breyer might be proud. That would be murder in a state with a Good Samaritan statute.
Okay, Jon Macks, we've done, this is our seventh joke. I'm guessing if I have this right, you're not necessarily, there's another hypothetical, and so far you have not enjoyed the hypotheticals they've offered. So take it away, Jon Macks.
For me, it's a little confusing. Is Justice Breyer proud because an old lady has fallen into a manhole, or is he proud because it's an extreme hypothetical? If he had just said because the person has an animus to little old ladies, like Justice Breyer. Now that to me is funny because, as we know, as the great Mel Brooks said, slipping on a banana peel, not as funny as you avoid the banana peel and then fall into the open manhole. So to me, I'm assuming that he was trying to make this about Justice Breyer loves extreme hypotheticals. I'm assuming that. In that case, it's inside baseball knowledge again. There are 30 people who get that. They happen to be in the courtroom. It's Gilbert Gottfried said, people always come and say, you should have been there when Bob stripped over something at the office. And Gilbert say, I wasn't there. If I had to be there, it's not funny. If you have to know this, it's not as funny. Again, to me, though, if he's talking about Justice Breyer doesn't like little old ladies, that's hilarious to me. So given that it's a little confusing, I give it a 6.
Okay. And Justice Jon Macks, if approved by the Senate, you would steer away then, if I'm hearing correctly through all these, steer away from the hypotheticals, just go right for the hard case sound, the punchline at the end.
Yeah, exactly. Okay. Or if you're going to do a hypothetical, make it a funny one. Exactly.
You're allowed to do hypotheticals and just make it funny. All right, we have one more to play, and then we do have a bonus clip at the end of this. Finally, one more argument from this current term, Boafra versus Mayorkas. The Supreme Court heard a case on whether a visa petitioner may obtain judicial review when an approved petition is revoked on the basis of non-discretionary criteria. You'll hear Justice Elena Kagan, and for the respondents, Colleen Rowe Sinzdak.
Well, I guess, that the in general in that sentence, is it in general or is it always? Like when you talk to them, do they say, of course we always revoke?
Well, I think quite honestly, the problem is that this is being done by individual adjudicators who have been given discretion under the statute. And so what they are telling me is that to their knowledge, where the evidentiary burden is satisfied, the agency generally is going to revoke if it determines that there's been a sham marriage. But not that the statute requires it. And that's the key question. And I just want to make clear, because I think it's getting a little fuzzy. We're looking at discretionary authority. And so if I can just give kind of my own child hypothetical, if I tell my daughter that she may have dessert after dinner every night, she has discretionary authority to decide whether to have dessert. As a practical matter, she is going to eat dessert every single night. I can assure you of that, but I have given her discretionary authority, and so if there was a judicial review bar, it would cover.
But your daughter would be able to tell you, I have a policy of having dessert every night. So I'm asking, do they have a policy of always revoking?
I think what you have seen is it's not on automatic grounds for revocation.
Okay, Jon Macks, that was our last clip and had the biggest laugh of all of them we played. Take it away.
This one I'm kind of torn about because it got a laugh. And it got a big laugh of everything that's played. So you've got to give credit for that. I thought that the Colleen, whatever her name was, Colleen, that hers was just as funny. As a practical matter, she's going to eat dessert every single night. And then Justice Kagan's going, I have a policy of having dessert. The wording's off a little bit. I would give more props to Colleen, but the fact, and it's kind of like, I'll call it a Facebook mom jeans joke, that like you see it on Facebook or Meta, whatever it may be now. Again, but the fact is, it got a laugh. We have a thing we used to say, it sounds like a joke. Sometimes it may not be a joke, but it sounds like a joke, and therefore people react and laugh. But if you go back like a minute later and go, what was I laughing at there? Again, I'm going to give her credit, though, simply because it got a laugh, and give her a 7.
Okay, well, 7 is not bad. That's pretty good on your scale so far. Okay, and the big takeaway: Chief Justice John Roberts scored the highest score of all
so far.
So far. Jon Macks, before I have a bonus clip to play and get your reaction to, but before we do that, 2 questions, unscripted, and you don't know about this. For our listeners who've enjoyed your comedy and your jokes, how can they consume more Jon Macks content? What books can they buy? Where can they see your work, and so on?
Yeah, it's in terms of seeing my work generally is obviously through the people I write for. Whether it's, they should see Steve Martin and Marty Short on tour. Which I believe starts again in August. They should, see whatever Billy Crystal's doing next. They should, when Chris Rock is doing a special, do that. See that. In terms of me, really, I summed up a lot of my career in monologue, What Makes America Laugh Before Bed, which was really a look back. It was part autobiographical and part trying to put things in perspective. But the caveat, it was written in 2014. Then 2015, I did a little follow-up. And so much of comedy and late night has changed since then. It's maybe like a 1920 medical book at this point saying, yes, you make sure you use the brown leech from Virginia as opposed to the yellow leech from Connecticut. It may be a little bit out of date, but that would be it. But really, I always say, see the people that I write for. See the ones when they're on tour. And again, you will never be able to tell my little bit of help that I give them. As I always say with the greats, I basically type. They talk, I type.
Second question, Jon Macks. We're sitting in the studios of C-SPAN Radio. I'm going to put you on the spot. What's your best C-SPAN joke?
My best C-SPAN joke?
Or do you have any jokes about C-SPAN?
It's played such an important role in American culture that one does not make fun of the giants. It's the Mount Rushmore of C-SPAN radio type shows. I really don't have a C-SPAN joke. Anything I would do would be making fun of it a little bit, which I would never do. You never make fun when you're a guest in someone's house. Perfect. So I will let that one go. Also, a very firm rule, Howard, when I'm not getting paid, I never give it away for free. But other than that...
I have to ask you this. It just occurred to me, Jay Leno and you wrote for Jay Leno for many years, he used to have a joke that he would use, I think every time we had an anniversary of C-SPAN, he would say, I'm going to butcher this. Cameras are working out so well in Congress, they're thinking of putting cameras into other high-crime areas. I don't know if you had a role in that joke at all. Or
I did not.
Okay.
It's interesting, Howard. I figured it out. I wrote about 100 jokes a day when I worked for Jay, and a little bit over, and I think it was 4,610 shows, and then count with bits. It's about 500,000 jokes, and I had 18,000 on the air. Sounds impressive until you realize that means that 482,000 are in a landfill somewhere. People go, well, what's your favorite joke? And I don't really remember any. I remember some that got crickets. Nothing, but because they're topical, you really don't remember it. And I remember of all the jokes I've written, probably the biggest cricket one I got was one at the Oscars in 2004. Did one with Billy Crystal. It was the year after Passion of the Christ, and Billy was going to come out. And you do that opening sorbet joke. It's that first, welcome to the Academy Awards, Sundance by the Sea. Whatever you're going to do. And the joke was a little bit different this year. Our entire monologue is going to be in Aramaic. We thought it was hilarious. Billy did it. It's his joke. It got nothing. And you can see there's a moment he just looks at me to the side it didn't get anything. But I remember the crickets, the ones that didn't work, as much as anything that worked.
Well, John, we appreciate you allowing us to charge you the nonprofit rate of nothing for coming in and doing this. And now the long-awaited bonus clip. We'll get Jon Macks' reaction to one of the funniest moments from a Supreme Court justice. It's June 29th, 2010, the confirmation hearing for Justice nominee Elena Kagan. And she gets this question from Senator Lindsey Graham.
Now, as we move forward and deal with law of war issues, Christmas Day bomber, where are you at on Christmas Day?
Senator Graham, that is an undecided legal issue, which, I suppose I should ask exactly what you mean by that. I'm assuming that the question you mean is whether a person who was apprehended in the United States is...
No, I just asked you where you're at on Christmas.
You know, like all Jews, I was probably at a Chinese restaurant.
Great answer. Great answer.
You know, I could almost see that one coming, and I thought,
Me too. So you were celebrating...
Senator Schumer explained this to me earlier.
Yeah, he did.
If I might, no other restaurants are open.
Right. You were with your family on Christmas Day at a Chinese restaurant. Okay.
Yes, sir.
That's great. That's what Hanukkah and Christmas is all about.
Jon Macks.
I loved it. I thought it was a killer joke. I would have said it. Again, it almost meets the definition of low-hanging fruit, but it doesn't, because it was so in the moment. It was so perfect. I mean, again, she could have tightened a gun. Like all Jews, I was at a Chinese restaurant. Again, whenever you put in this qualifying probably, you're stretching it out. But it's a great joke. I would have said it in that moment. It was, of all of them, I give it a 9.0.
Oh, my goodness.
I give it slightly above the great Justice Roberts joke
my
earlier.
goodness.
I would love to see Justice Kagan and Justice Roberts on Last Comic Justice Standing. I think it would be a great reality show, the two of them.
Do you think the senators who came in, I know the senators all have to say something, were they as funny as her in the moment, or would you just say, just let me have the joke and move on?
They should have known they're not going to top it. They're trying to build on somebody else's comment. Not funny. It's like a comic trying to top another comic, but when something just lands so perfectly, let it go and move on.
It's not ad lib. It's
basically
not
they were basically repeating the premise
right,
is what they were doing. If I would do it, I would probably say Roberts might be more of a natural. I say Kagan also a bit of a natural. She had with one joke wasn't that great. She might be good in the Catskills to start out. And an MC would be good. Roberts also good. Gorsuch has potential. I think with a lot of work, I think going on the road, he'd be good. Justice Alito, I think, should stick to law.
And Jon Macks, thank you for joining us. Any final remarks here? Any closing statements as they do in the government and the official proceedings?
No closing statements. This has been so much fun, and what I would tell most of the justices, stick with your day job.
Very good. Jon Macks, thank you for joining the C-SPAN podcast, The Weekly.